I mean, really. Hello again. This is Ben Hitchcock Cross talking to you today. I've got pretty much the most shocking thing I've seen in quite a while, so I can't wait to get it to you. Let's turn this up a little bit here, see how that helps. Um, we have a contract here between the Department of Workforce Development and the Department of Hearings and Appeals. And it controls the case in Faleron versus Milwaukee Public Schools, and somehow I think it's in the favor of mostly in the favor of Calvin Fermin, administrative law judge for the Department of Workforce Development. So once again, and again, this is the case that Peter Reinhardt, administrative law judge, knew about the conflict 10 months earlier. We've got that on video. They are really taxing my editing skills here, my editing time. But waited until the day that he was to appear on the hiring committee for Calvin Fermin to disclose. He didn't even disclose that. We found that out from public records, to recuse himself from the case. Subsequently, every other ALJ recused themselves from the case on the appearance of bias. And then they thought that was clever for a lot of different reasons. But ultimately it was held up by Ramona Natera and Laura Amundsen on the grounds that it was held up to wait for another case, although we didn't consent to that. So then we withdrew the other case in protest here, and it still took them 5 months to make a contract with the Department of Hearings and Appeals, which I think is a travesty and is voidable. It cannot stand, in other words. And to do that, I think, we just need to take a broader look, I guess, at what and why they would do that. This document is going to tell us why. First, we're going to look at a little Supreme Court law, though, as everybody should, from 1927, called Tumey versus Ohio. And we're going to talk a little bit about pecuniary interest and what that means. So, like any good bit of legal reasoning, we're going to look at the rule first, and then we'll look at the specific facts that we have here. But to me, it seems a little bit concerning that there is a contract out there that discusses the judge's pay and the rule of the case that the judge must follow. This isn't a mediation. This isn't something that's agreed to by the parties. This is something that's imposed on the worker by the Department of Workforce Development. And again, in my mind anyway, for the clear purpose of benefiting Calvin Fermin and the Department of Workforce Development. So we're going to go over again the rule for Tumey versus Ohio. Generally, I want to put it like this. Brief history. Up until since common law, and basically from the beginning, which we'll get into, there have been one standard for bias in a hearing, and two things, which is like a direct relation or pecuniary bias. Bam, either of those things, you don't need a statement. Or number three, basically something on the record that shows direct bias. And, we've talked before about how it's not enough that the other thing, again, is if you're on the other side of the V in a case, if you ever represented one of the parties or something along those lines, that's automatic. But otherwise, you've got to show something on the record that indicates bias, which, a smart judge isn't going to give you. So that is, that's the old standard. And that had been the standard up until, I want to see, 2000 and I don't know what, 2000 something. It's called Caperton. And that's when there basically was a Southern Supreme Court justice, I think Georgia, but again, only read it a couple of hours ago. That justice was getting campaign contributions in really an outrageous amount. That really gave the appearance here that it was a quid pro quo. He was taking basically campaign contributions directly from one of the parties that was in front of him. And that was held to be sort of the unacceptable appearance of bias. So just explaining that out before, under common law, under England, you had to have something, again, kinship, money, something on the record. Okay, now we've sort of opened the door, and we've got this unacceptable appearance. Now, only thing I want to note about that for right now, because we'll talk about that's a whole other video, is this. The Wisconsin Department of Workforce Development is working on the old rules from the 70s, where you have to, you just got to point to something on the record, and they don't quite understand the unacceptable appearance of bias. They usually are a couple years behind. I will admit to that, but that is something to note. So what we are going to go is the old version now. This is a Supreme Court case that's cited by the 70s Supreme Court case that's talking about bias, that basically again says if you want to get rid of a judge, you got to have something on the record. And we've talked about, I think, why that's probably a good reason. And it also, I think, encapsulates the same sort of reasoning from the common law uh, that have to do with judicial immunity, total judicial immunity, even for, obvious crimes. And that's because we're not going to get involved. You can have the case overturned. That's what the appeals process is for. But we're not going to go after judge. We're not going to allow you to create an issue going after individual judges. And that's part of the dissent here, and always is, we're afraid that if we open the door past an actual statement on the record, something that we can verify here, that we're just going to open the door to feelings. And everybody's going to have a feeling about their judge, because everybody does. All right, we're going to be editing a little bit of this, but this is so again, Tumey versus Ohio, 1927. And under the statutes of Ohio, offenses against state prohibitions involving a wide range of fines enforceable by imprisonment may be tried without a jury before a mayor of any rural village situate in the county, however populous, in which yada 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 willful disregards. Okay. Prosecute before the mayor. In addition to his fees and costs, so clearly, I guess I got to read the whole thing. In which offenses occur. His judgment upon the facts in final and conclusive, unless so clearly unsupported as to indicate mistake, bias, or willful disregard of duties. The fines are divided between the state and the village. The village, by means of the fines collected, hires attorneys and detectives to arrest alleged offenders anywhere in the county and prosecute them before the mayor. In addition to his fees and costs amounting to a substantial income, the fines offer a means of adding materially to the financial prosperity of the village, for which the mayor and his executive capacity is responsible. Okay, so that is what we are going to find to be illegal. This sort of scheme here, statutory scheme, no doubt about it, but a scheme here, in a plan in which the police and the village and the mayor's salary are being paid for directly out of fines from uh, a court that's being run by the mayor. That's what we're talking about. Okay, that here is clearly violates the 14th, meaning the states can't do it because it violates due process. That's what we're talking about. Okay. When a state deprives a person of liberty or property through a hearing held under statutes and circumstances which necessarily interfere in the course of justice, it deprives him of liberty and property without due process. Okay. So that doesn't matter which side you're on. If you have an unfair um, tribunal, it's off. And see, what's great about everything that we're reading in here is that it's the Supreme Court of the United States. So unless there's another decision going forward that says that this is wrong, and it's, again, as I explained, it's just added to that, then they got a problem. So Moving on, a financial interest of a court in its decision constitutes that court an unfair and partial tribunal within the prohibition of the 14th Amendment. The mayor who tried this case was personally financially interested in his decision, for under the Ohio law, the mayor can receive no fee unless he finds the defendant guilty. Okay. What would be the analogy in civil court here? Um, so I guess we would have an analogous situation if the hearing officer, in this case, the hearing examiner, wouldn't receive a fee if they found in favor of the complaint. Okay, I think that's a rule, or the respondent. They wouldn't receive a fee if they found in favor of one of the parties. Okay, because this is different. This is only if he finds against one of the parties does he receive a fee. That's slightly different, but the outcome is still the same. Okay. When the question is merely whether the cost should be paid by the plaintiff or defendant, is held that the judge is not disqualified because of the financial interest under Ohio law. However, since the mayors of the village sitting as courts of justice do not receive any fees unless they convict, an entirely different situation is created. Okay. Now that's the question here. That's different. So that's saying whether or not the fees, if there's a fee that then gets paid to the police, okay? If they get the fee, whether the rules either way, then it's okay. But if he only gets the fee for making a particular decision, then it's a problem. That's, I think, what we're talking about. Now, aside from the personal financial interests of the mayor, the record is clear that the mayor was operating the court in order to make money for the village. Another issue, of which he was executive head and which was in a bad financial condition. Okay. The greater a fine assessed by the court, the greater the amount of money which the village would receive. The mayor's interest as an executive head, his operation of the court as a commercial venture to make money for the village, made his so-called court but a mask and a sham, in which there were the forms of judicial proceedings, but in fact, no real judicial hearing. Dang it, hate to be sitting as mayor in that situation. Dang. So-called court but a mask and a sham. Yeah. Okay. A trial before a tribunal financially interested in the result of its decisions constitutes a denial of due process of law. And you don't have to take my word for it. We got like a paragraph there of the law saying something else. Oh, here's another page of the law saying something else. Okay. All right, let's move on. All questions of judicial qualification may not involve constitutional validity. Thus, matters of kinship, personal bias, state policy, remoteness of interest would seem generally to be matters merely of legislative discretion. But it certainly violates the 14th Amendment and deprives a defendant in a criminal case of due process of law to subject his liberty or property to the judgment of a court, the judge of which has direct, personal, substantial, pecuniary interest in reaching the conclusions against him in his case. Now, we're sort of the point in time that we were really talking about at the beginning was 1976. The law had progressed a little bit since then. This is a straight explanation of what the common law was, for 500 years, basically. And why the scheme set up here, which is admittedly slightly different than what we're talking about, is even against the common law principle, and they can't do it. Okay? The mayor of the village of North College Hill, Ohio, had a direct personal pecuniary interest in convicting the defendant who came before him for trial, and the $12 of cost imposed in his behalf, which he would not have received if the defendant had been acquitted. This was not exceptional, but was the result of the normal operation of law and the ordinances. Counsel for the state did not deny this, but assert that the validity of the practice as an exception to the general rule. Boo to boo. These cases show that in determining what due process of law is under the Fifth and 14th Amendment, the court must look to these settled usages and modes of proceeding existing in the common statute of England before the emigration of our ancestors, which were shown not to have been unsuited to their civil and political conditions by having acted upon them after the set. Oh my gosh. That was a really terrible way of saying we're going to go take a look back. The state's arguing that we're only looking at the common law and not the statutes. Counsel contends that in Ohio and in other states, in the economy which is found necessary to maintain the administration of justice in the inferior courts by justices of the peace and judicial officers, and like jurisdiction, the only compensation which the states and the county and the townships can afford is the fees and the costs earned by them, and that such compensation is so small that it is not to be regarded as likely to influence impropriety a judicial officer in the discharge of his duties or as a prejudicing the defendant in sentencing justice, even though the magistrate will receive nothing if the defendant is not convicted. Okay, de minimis argument. It's just tiny. But let's move on. All right. Gulp. We have been referred to no cases at common law in England prior to the separation of the countries from the mother country, showing a practice that the inferior judicial officers were dependent upon the conviction of the defendant for receiving their compensation. And we could go into the history of the 12th century of Richard III. Oh my God. It was provided that there should be a commission of the judge and how justice was indicated there. But we are not going to do that here. I just will say this, because this is what their pronouncement of what the common law is. There was at the common law the greatest sensitiveness over the existence of any pecuniary interest, however small, of infinitesimal. In the justices of the peace, we find the following. The general rule of the law certainly is that justices of the peace ought not to execute their office in their own case, and even in cases where such proceedings seem indispensably necessary, as being assaulted or personally abused, or their authority otherwise contemned while in the execution of their duties. Yet if another justice be present, his assistance should be required to punish the offender. Okay, we can go on, but we can say that England thought that, again, pecuniary interest, direct relationships, etc., you're automatically out. Okay, because the question, and we won't go into it further here, but ultimately it's going to be, and if I can find it, I'll let you know, is okay, here the judge is getting direct money, but what happens if just his office is getting money? And it's my understanding here that it's saying basically the office in and of itself, the mayor, the village, is not supposed to have its budget based off of the fines. They might be getting paid. Here's how we get around that, and then I'm going to conclude this section and read the dang thing. Sorry, we're at 20 minutes. I'm going to do that. It's like this. Village gets some money, fine. That's not necessarily the budget of the mayor. Okay. The mayor, so well, in Milwaukee, we've got a municipal court. The judges there, the fines from there go to the city of Milwaukee. They don't go to the court budget that is granted to them by the common council here, who approves that. They get a pot of money. It's not dependent upon how many cases they bring in at the end of the year. It's dependent on their needs. That's the distinction. That's what we're talking about. Fines absolutely can go to the municipality, without there necessarily being but it's a question of what the budget of that office is. Okay. So now we'll take a slight pause for worthy cause. All right. We also, by the way, have a recording of the judge, the new judge here, um, or examiner. Um, we've got him talking about this, and we'll have to play that because we've got it. All right. October 2nd, 2024. It's just what was really weird about that was what it took to get this document. And, he admitted it only, I think, when we demanded it. I think that's fair to say. But what it took to get this document was surprising. And their attitude towards giving me the rest is also surprising. But, they possibly don't interact with deliberate indifference Wisconsin to the extent that others have. So we'll get them up to speed. 2, Brian Hayes, administrator, Department of Administration. Department of Administration, Wisconsin is this catch-all agency where they stick all these things in there, but they also have a lot of HR and administrative things. You'll remember, for example, if the Department of Corrections wants to skip in a progression, they got to go to a DOA person to whatever the heck. But it's all nonsense. Okay. From Ramona L. Natera. Ooh, I wonder what the L's for. Administrator, DWD, Equal Rights Division, regarding terms of engagement for Division of Hearings and Appeals Services per WISSTAT 22743. I want to point out, now I asked for this 8 months ago, 9 months ago. They didn't give it to me until 5 months ago, and then they said my request was moot because they were giving it to me. And 22743, we're going, that is what allows them to contract with the Department of here. Let's just see what it says here, just for fun. Well, who knows? I guess I read that before. 227, that's our contested administrative hearing statute. Divisions of Hearing and Appeals. The administrator of the Division of Hearing, Appeals and Department shall serve as an appointing of all hearing examiners. So their boss is the administrator. Okay. Okay, so we know one thing we know is Brian Hayes, administrator, can terminate the hearing officer. Good to know. Assign a hearing examiner to preside over any hearing of a contested case which is required to be conducted by the Department of which is referred to the state superintendent. No. Hearing examiner under case. Well, he can sure assign a lot of hearing examiners. Whoa. Well, now we got a problem. Sorry, I didn't read that one, and I guess you can't see either. But good thing we looked at this joker. 22743C says that this administrator of the Division of Hearings and Appeals shall supervise hearing examiners in the conduct of hearings and the rendering of a decision if a decision is required. Well, that's kind of problematic. So this guy has a boss who's going to supervise him in the rendering of a decision if a decision is required. God, I mean, what does that even mean? How does that jive with the wow. All right, we'll find out. Well, statutes are assumed to be orderly and work together. So if you think of a conflict in your mind, it's probably Hugh and not the statute. So that's who that goes. All right. We will take a note, Calvin the old joker, and move on. The Department of Workforce Development, DWD, and Division of Equal Rights. ERD is the entity responsible for investigating, issuing determinations, conducting administrative hearings related to civil rights complaints filed under the Wisconsin Fair Employment Act, WIFA, in a fair and unbiased manner. I added that. All right. Pursuant to WISSTAT 227431M and 22743 sub 3 sub E, the Division of Hearings and Appeals may contract with agencies to provide contested case hearing services and set fees for these services to cover total costs. And see, that's the problem that I think we're going to run into under our analysis that we discussed before, right? They can receive fees and they can provide services, but the fees and the services can't be related to a particular outcome. That's, I think, the problem uh, that we, the rule that we read, sorry, the rule. Now we're getting these facts here. With this letter of engagement, ERD enters into an agreement with DHA to conduct the hearing and issue a written decision in Teresa Falderon versus Milwaukee Board of School Directors. Here we go. Under this engagement, the DHA ALJ shall follow the hearing procedures established under WISTAT 1139 and Admin Code 218. Okay, first problem, that's wrong. They also need to follow 227 in its entirety, particularly 46, in my opinion. That's when we get to hearing examiners and examination of evidence by an agency. And so that, I think, regulates this hearing more than anything. And so I think we have the first misstatement of the law in this contract here. And again, it's problematic that they're stating out WISTAT 111.39, that's the Fair Employment Act, and the Admin Code 2118 is their interpretation of 227. That, I think, is the problem, is they're prioritizing and not even mentioning, frankly, the actual law that was enacted by the people of the state of Wisconsin. They're talking about their rules, which are simply policies set forth by the governor, which are different. Further, and this is, I think, where we get to the crux of the matter, the DHA ALJ shall adhere to the pre-hearing actions as the law of this case for the proceeding. And well, you can tell me when you watch the video of the pre-hearing conference if that judge explained to us that was what was going on or something else as the law of the case. So that means that and this is, keep in mind, all of the ALJs recuse themselves because of the appearance of bias. So presumably all of their decisions are going to have the presumption, are going to be presumably biased. But for some reason, we're baking in by contract all of the decisions that the previous ALJ did. And we could go over all of them, but there are 13 of them here, including his order of recusal. That's the one that says that he knows Calvin Fermin to be, true, trustworthy, and brave, or something along those lines. That's outrageous. Why there's two things. Why would, for any reason, the previous biased judge's decisions be the rule of the case? Why would we assume that we're not starting over from the beginning? Okay. And number two, what business is it of the Department of Workforce Development if these decisions are binding or not binding? And why, again, did it take them 5 months to come up with this? And this is what they came up with without consulting any of the parties. This, in my opinion, 100% favors. It's true that we got some decisions in favor of us. We got some decisions that weren't in favor of us. My position is all of those decisions need to be thrown out because the judge was biased. And I think his appearance of bias is outrageous because he never ever addressed this. We can call this preemptive recusal, to not have to deal with the fact that it was clear that the real reason that he was actually recusing himself was in coordination with Ramona Natera, because there's emails with him. I mean, it's just disgusting that there are judges who are communicating with their boss, and that they are being supervised in their decision, and yet they are claiming to everybody that it's the administrative law judge and the administrative law judge only who's making the decisions, because it's simply not true. And it's a disgrace for the state of Wisconsin that this is allowed to continue here. Um, but it's, to me, in my mind, that is the bottom line, is all of the decisions in favor of Calvin Fermin, who's named specifically in many of the decisions that are listed here, that this is outrageous. Again, um, that's why I would say to you that this contract benefits, one of the beneficiaries of this contract is Calvin Fermin. Not the parties. Certainly, we were never consulted on any of this. This was all a decision made behind the scenes without our involvement. This is, again, locks us out, because and this is the problem. We had this pre-hearing conference. We discussed motions. At no time did the judge tell us, because we said we were going to argue against this, that for the motions. At no time did the judge tell us, the hearing examiner tell us, that he was contractually obligated to rule against our motions, to have to throw out all the original decisions of Judge Reinhardt. At no time did he tell us that. And in fact, it really took the public records law for us to get a copy of that document, although we should have already had it as parties. Because what is this if not an ex parte communication between the Department of Workforce Development and the new ALJ? And the fact that the ALJ, I mean, it's outrageous. It's absolutely outrageous that they presume to it, because again, it puts the lie to their claims that Secretary Natera, Administrator Natera, isn't involving herself in cases, that Maria Seltzer doesn't involve herself in cases, that Secretary Petchacek doesn't involve herself in cases. We know that from the hot mic, but here again is written, their own signed evidence. It's outrageous. This case is a hearing on the merits. As stated in the pre-hearing conference report and scheduling order, this issue is to be decided at the hearing is whether the complainant established by a preponderance of the evidence that the respondent violated the Wisconsin Fair Employment Act by engaging or permitting sexual harassment, discriminating against the complainant in promotion because of race, discriminating against the complainant because of sex, and discriminating against the complainant because the complainant opposed a discriminatory process under the act. They're quoting from the biased order. Within 7 days of the date of this engagement letter is fully executed by the parties, the ERD will provide a complete copy of the electronic case file to date to Department of Hearing via email. When we asked for this document, this is a pretty good indication of disingenuousness here. When we asked for the entire document, they sent us a bill for $1,000 to print out the document and give it to us. So, in response, they are now having to deal with some significant public records requests about, and we're going to learn a lot more about their agency, because they decided to play games with public records. So that's how that goes. But they'll be producing, the public is going to need to request some more records here, because this says that they got the case file electronically, and they're acting like it's 2010, and you can pull this kind of stuff where you have an electronic file and you're going to print it out just to waste paper and to cost people money. And the first person who said that was the ALJ. We've got that on recording. I mean, literally, we don't even get to the next one and we've already got a problem. And 34 minutes been buried, deleted again. All right. Pursuant to longstanding case law, there is no summary judgment. Again, who are they? Who in the heck are these people to say if there is or is not summary judgment? Pursuant, the method of recording the hearing shall be as allowed under this rule. Within 90 days of the final day of the hearing, after that's trying to keep out you too, the way they put that there. That within 90 days of the final day of the hearing, the closing arguments, or if applicable, the receipt of closing briefs, the ALJ shall issue a written decision. Now, here we go. Within 15 days of the issuance of the written decision and order, all files and records generated by the DHA, which are considered part of the case file, will be returned to the ERD via electronic copy. The DHA will not be the custodians for these records. That's their opinion. The fee charged for the services rendered to the ERD. See, that's the problem here, is that the ERD really feels that it's the bureaucrats feel that they're a party to the workers' lawsuit. That's what that is. Let's keep going. The fees charged for the services shall be set at $135 an hour, $350 filing and docketing fee and expenses. The fee shall cover the total cost of the services actually provided and billed at the rate set per WISTAT 227-4333. But you see the problem here is that if the judge were to rule against any of these motions, then that would be a breach of the contract. Then they wouldn't get paid their reimbursement. DHA agrees to track and report actual costs incurred under this agreement. Invoices to be received no later than 15 days after the close of each month during the engagement. This engagement letter shall be effective as of the date it is fully executed by the parties until such time as the activities outlined herein are complete and the case has been returned to the ERD unless terminated. That'd be great for them, wouldn't it? In writing by either party. The engagement letter may be amended as necessary to conduct additional proceedings in the case of remand after appeal, but only upon the express written consent of the parties. And then it's signed Brian Hayes, the administrator, Pamela McGilvery, the deputy secretary, and Ramona Natera. Not the parties. No, not the parties. Right. So that there is, you be the judge of whether or not they're benefiting financially from preventing access to Calvin Fermin and other things like that. Let's just talk about that. All right. So there we are. The Department of Workforce Development contractually obligates the Department of Hearings and Appeals to bake in the bias of Reinhardt in favor of Calvin Fermin and others. So, thanks for sticking with us. We'll keep you informed. It's on the one hand, it's frustrating, but on the other hand, they put it in writing. So that's the nice thing about when you're back on the 1927 rules. That, so to me, seems like a clear indication on the record of bias, both pecuniary and otherwise. That's a decision that's a clear intent to rule against one of the parties. Yeah, it's pretty outrageous. I can now, I after reading that contract, I felt somewhat that things were going to be better now, but after reading that contract and then rewatching the video, I have other views.